In 2017, Brandy Levy was a 14-year-old high school student in Mahanoy, Pennsylvania. She tried out for the varsity cheerleading squad, but she didn't make the cut. Coaches told her she needed to spend another year on junior varsity.
She was very frustrated. She was very angry. And on a Saturday, she went with a girlfriend to a convenience store.
And she put a snap on her Snapchat story.
She took a photo of herself with her middle finger extended to the camera, and she said, among other things, F cheer.
So Brandy does not intend for this to spread widely. It's Snapchat, it's gonna disappear. She's got a limited circle of friends who see it.
But we all know how that goes.
Unfortunately, one of her classmates took a screenshot, which she showed to her mother. And even more unfortunately, her mother was a coach for this cheerleading squad.
The school punished Brandy by suspending her from cheerleading altogether. They claimed that her Snapchat message was disruptive and that its vulgar language violated the team's code of conduct.
And just like many other Americans who've ended up at the Supreme Court, Brandy Levy thinks this is wrong, and she thinks she's going to stand up for her rights.
With the help of the ACLU, Brandy and her parents sued the Mahanoy area school district. She believed the school didn't have the right to punish her for something she said off campus on the weekend.
It was an important question because the Supreme Court had never weighed in on students' speech rights when they are off campus rather than on campus.
Could she be punished for expressing her feelings on Snapchat? Especially, could she be punished when she didn't do it at school?
In the 50 years after Tinker, social media had drastically changed the way students communicate.
Justice Fortas in Tinker says it can hardly be argued that students shed their constitutional rights at the schoolhouse gate. Well, in the age of social media, where does the schoolhouse gate begin and end?
Social media really blurs the line between on-campus and off-campus speech, because students may create the social media off-campus, as Brandy Levy did here, but it can be accessed on campus. And so something that's created outside of school can be seen, heard, read, spread around inside school. And it can be having direct effects on students during the school day.
Remember the Tinker test? It said students have a right to free speech in school, but not if it creates substantial disruption. So the school argued that if a social media post substantially disrupts what's going on at school, they should have the right to punish that speech, even if it was written off campus.
And the lawyer for the ACLU, which was representing Brandy Levy, she said if schools are allowed to do this, the students would be carrying the schoolhouse on their back all the time. And it's a great image that you can't shake free of the authority of the school.
In other words, anytime a student posts something online, they would have to think about whether or not the school could punish them for it. So you might be thinking, wait a minute, Brandy wasn't talking about war or politics. She was just venting about cheerleading in a way that some people found offensive. Why should we care about protecting this kind of speech?
No, Brandy Levy wasn't talking about the Vietnam War, but she was talking about the operations of the government entity that was exerting control over her life. And she was saying, I've been treated unfairly.
Even though this is not political speech, it is important for individuals to be able to convey their feelings in a powerful, emotional way. And that's a part of what the First Amendment is designed to protect.
In 2021, after hearing oral arguments remotely, the Supreme Court ruled 8-1 in favor of Brandy Levy. The court said that Brandy's post did not cause substantial disruption at school, and because of that, her off-campus speech was protected by the First Amendment.
The court ruled for Brandy, but it didn't rule for Brandy in a way that creates clear guidance.
The court said that the First Amendment limits the school's ability to punish off-campus speech, but doesn't completely prohibit it. In certain situations, like cases of online bullying or harassment, the school might be able to punish off-campus speech, but the court didn't provide clear rules.
The court seemed very aware of the difficulties that different kinds of situations might present, and they didn't want to write a broad rule that would tie their hands for those future cases.
Schools are in a very difficult position these days with respect to social media.
For example, if a student posts something online targeting other students that is racist or vulgar or sexually harassing, what happens if the school can't punish them? How can they provide a safe learning environment for all students?
Schools, coaches, teachers, principals need to have some tools to address proper norms of behavior.
These are all issues that schools have to grapple with, and it's not easy.
The ruling didn't make a bold statement for future cases, but it was still a very important one. It was the first time in 50 years that a student won a free speech case at the Supreme Court. Justice Breyer, who wrote the majority opinion, echoed ideals from the Tinker decision, saying America's public schools are the nurseries of democracy.
What Justice Breyer is expressing really is that schools broadly, as institutions, are meant to train citizens. And the way to do it is to allow young people to exchange their views, even when they are inappropriate sometimes, even when they are mistaken.
And whether students are talking about war or cheerleading or some other topic, the First Amendment protects them.